Good morning.
Good morning.
Welcome to an oral argument session of the 6th District Court of Appeal. We're being live streamed today, so I just want to call your attention to that. My name is Judge Nardella, and joining me on the panel today is Judge Smith and Judge Wozniak. We only have one case for our consideration today, and that is Stephen T. Smith as trustee of the Stephen T. Smith Revocable Trust Agreement versus Charles Babcock, 23-1049. Each side will be allotted 20 minutes for their argument. The appellant may reserve as much time as he would like. We traditionally reserve 5 minutes, but if you would like, is that acceptable? Wonderful. So as soon as you are ready, you may take the podium and begin your argument.
All right. Oh, you have a clock here. Do I push the green button?
Nope,
Oh,
I
you
got
do
that.
All right. Good morning. My name is Mark Yeslow. May it please the court. I represent the appellants in this matter, Mr. Smith and his trust. This is an appeal from an order granting partial summary judgment. The Honorable Judge Foster granted it on November 17, 2022.
Counsel, we're well aware of the facts, and if we could start with jurisdiction, because I think it will determine the frame in which we view this case, whether it's a non-final order.
It's a non-final order. We've already filed our briefs on that. I rest on those briefs, Judge. I think it is a determination of an interest in property, clearly.
Is it immediate possession of property?
The judge granted and said 30 days from now, from the order, before you all granted your stay, the property that is unquestionably, at least a portion of it, is Mr. Smith's, is going to be removed and destroyed.
Is dispossession the same thing as possession? And if dispossession is the same thing as possession, is dispossession the same thing as destruction?
I can't see how, when you take somebody's property and you remove it, you have the right to remove it, how you don't possess it to remove it.
Do you have any cases that deal with this subsection of the non-final rule and look specifically at destruction?
No,
Okay.
other than what we cited in our initial motion.
The non-final also allows for appeals of orders that would modify, change, create, dispense with injunctions. Is the nature of this order?
There's no injunction here. So it would be if we don't get it under the immediate possession of property, then it would be a petition for writ of certiorari, irreparable harm, which is clear in this case.
Okay. Is the irreparable harm analysis an objective or subjective test?
I would think it's an objective test.
Can you tell me why?
Because objectively speaking, you have to look at it from the judge's perspective and see if there's irreparable harm in this case.
Do we look at the statements that your client has made about the relief that they're seeking and determining whether or not they're going to be irreparably harmed by removal?
I think I understand where you're going with that, because I think the leaning of the argument is that he agrees the dock should be removed, so I think once you hear the whole argument, you hear that, yes, from my client's perspective, there will be irreparable harm.
Okay. And I understand where you're going, counsel, and I don't want to push you there. I'm actually going somewhere else. There's a lot of statements made throughout the filings, including the cross request for declaratory injunction all the way to the initial brief, which say things like this. Although the Babcocks are correct that it is undisputed that the parties agreed that the dock would need to be changed or replaced, the facts are disputed as to when the removal can take place.
Well, I submit that the facts are disputed when or if the entire dock has to be removed, because we consistently argued that there has to be a determination of the riparian boundaries, the water rights, and the respective parties. If Smith, I believe, Judge, as you know, there's in addition to the dock, there's a lift on towards Smith's side of the property, because we don't really know the property boundaries in this case. But if you remove that lift, he paid for that separately. That's part of what the whole argument's over. And if you remove the lift, that clearly is something he intends to maintain and to keep. He doesn't care about the dock so much, but he cares about the pilings and the lift. And so there's a little bit of a subtle difference between the two. The dock does not mean everything that's in the water. The dock means what the Oric Marine had a contract for each one of them to put part of the dock in. And that, I think, we don't care really if that's taken out. I just think before you do that, you have to say, we have to determine the riparian boundaries, what's on Smith's side, what's on the Babcock side. Because then I think once you go there, then the parties can do what they want with their pieces of the dock. If Smith thinks,
Just jump in. Didn't the appellee already concede that the boat lift is not subject to the order?
well, I mean, what we did is the motion for clarification because there appears to be one post that shares the dock and the lift. If we could just have an agreement that the lift stays, I don't think we would care about the dock.
The way I read their brief, on page 13, they say that the boat lift is not subject to the partial summary judgment order. So if there's a piling that connects to that boat lift, then it would seem to me that they're already conceding.
Then
that
we would have
piling
been,
stays.
that's not how I understood it, because we had a motion for clarification and the judge denied it, because what we wanted to know is how much of this dock and are you taking out? Are you going to modify or change our lift? Because if we keep the lift, we can move our own dock on the other side. There's
My
enough
memory
room.
is the court said the 6 pilings will go, is that correct?
I think,
So it was
yes,
more than just a summary, okay.
right,
And that you're telling us it would implicate the boat lift going as well.
right. And
Counsel, can you announce for the panel today each and every way you will be irreparably harmed if this order stands?
well, it depends on now I believe there's some confusion as to the nature of the order. That's why we sought clarification. But if the order stands as what we interpreted the order as, that everything goes, the lifts, the pilings, the whole dock, then we will be irreparably harmed. If it's just the dock and the lift, the 4 posts that hold this lift up remain, there's always conversations and people have conversations and it might be a miscommunication. And I hate to waste the court's time on something like that. But if we keep the lift, I think we're good. I think we're fine with that.
Are there any facts and circumstances where this dock would stay?
Let's face it.
In your preference?
Let's face it, the 2 neighbors, since 1965, there's been an easement on this property. Everybody's got along, but finally 2 neighbors did not get along. And now we're at a point in time where I don't think at the end of the day, maybe they can share the easement, but I don't think these people are going to be able to share much else at this point. Maybe in the future, but right now, I think there's no way, conceivable way that these people will be able to share anything at this point.
That's interesting. So we have a shared dock.
A shared easement.
We have a shared easement and currently there is a shared dock.
There's like strings around. If you saw it, there's a perimeter that the Babcocks had put like ropes around it. And if we cross it, they're considering us trespassing.
Is it possible?
Taking pictures of the kids doing that.
Is it possible to put 2 separate docks?
I think there is. I think you keep the boat lift where it is. I think there's clearly a way that we could put an access to the lift on, and I get my directions mixed up, the side away from the Babcocks, on that side of the property. Because we have I don't know if you've seen an aerial, he has it, but it's a cove. It's like this. So everybody, it's a big issue. Follow the property lines out. We won't even have access to a dock because it kind of cuts us off. But on the other side, I think there's enough room that we could have a dock, an access point to get on and off the boat.
Would
if
that
we
obstruct views or infringe on riparian rights? Or?
Well, that judge, their brief, they backed off the riparian right issue. They said we don't have to determine that because what they have a picture of, they still have a beautiful view of the water. I mean, you don't see it in the pictures, but they have a tremendous view of the water. They still have it. So if they want to go into that, we're going to go into that. Still an issue in the trial court. It's get a determination of the riparian boundaries. But I don't think we're going into that today. They backed off that. That's not an issue they brought up in their appeal. In their response to our appeal. I'd like to make a few points if I can with the time I have. Okay, so I think the order, a couple things I'd like to point out is that the order, the appellees have they said I misrepresented fact at the lower court goes, there was an agreement to build the dock. The order, paragraph 3 of the order granting summary judgment says that they agreed to tear out and replace it. The record shows there's 2 signed contracts with Oric Marine for this dock that was built. If Oric Marine built something that wasn't agreed to, they would be a party in the litigation. Mr. Babcock, if you look at his sworn affidavit, and that is, let's see. App 4, appellant's app 4, paragraph 4 of the affidavit, he states unequivocally, quote, I agreed to and did pay Oric Marine Construction for the portion of the dock constructed within our property line. Exhibit 6 of our appendix is the contract Mr. Babcock signed. Mr. Smith said under oath in his deposition page, which is a part of Exhibit 5, you have to go down to page 53. Frankly, it might be easier to look at the appellee's appendix for that because we kind of condensed it with several exhibits. But page 53, he says he signed the contract. There's no doubt he signed the contract. He just says he didn't look at it as closely as I should have. The other thing I'd like to point out is all that about the dock being terrible, that's from Mr. Smith's vantage point as to what the Babcocks believe.
Well, they seemed like neighborly conversations, like trying to work something
Right.
out.
I mean, if you look at it, I think my neighbor put a umbrella thing over his dock and it messed my view, but I mean, it didn't kill it, you know? And I think if you look at Mr. Babcock's property, which we're ultimately going to do, you see it still has a tremendous view, tremendous. And the other thing is Mr. Smith said, I'm perfectly happy with the dock. So if you rip it up, especially the lift, if you rip it up, it's not to his benefit. He paid for some of it. You know, I mean, it's obviously a property right. He paid for some, he paid for the lift. And now, as I interpreted the order, everything goes. If we still keep the lift, I think we can do away with the shared dock part. That's not the big deal for our point of view. It's the lift. We separately paid for it. And I think before we start lifting that out and taking it out, there has to be a determination of, is it within our riparian boundaries or not? If it's within our riparian boundaries, we keep it. If Mr. Mr. Babcock and his family, it's within their boundaries, we're going to have to do something else about it. But the riparian boundaries, you can see from the exhibit he has, the riparian boundaries won't work laterally straight out from the property. It's a cove. So everybody is going to have to compromise, and that's that Hayes case that we quoted. You know, it's equitable determination. You can't do it through a mathematical formula. The judge is going to have to look at it, make sure we still have access to the water, try to accommodate Mr. Babcock's view, and do the best you can with the limited space, which is what.
Counsel, if I may.
Sure.
If we're under the certiorari standard, what's your irreparable harm if we're just talking about the boat lift?
You mean the dock? If we're just talking.
No, I'm talking about the boat lift.
Well, if you
Just
take the boat lift out, we're done. I mean, we paid thousands of dollars for that.
But I mean, I assume it's a piece of equipment, correct?
No, it's 4 pilings with levee. It's got gear, you know, something to lift and drop the boat down. It costs thousands of dollars.
But counsel, I think I'm going to follow up to Judge Smith's question, and I'm sure he can do it better than I'm about to, so please interrupt. If you take the boat lift out, what irreparable harm flows from that cannot be remedied at a final judgment stage if they were to give you the monetary amount that boat lift represented to reinstall? What is the irreparable harm?
Well, you just added something to it that I don't know if we can do. You said if they take the boat lift out, where are we going to get paid for the boat lift? I mean, there's no claim. We have no claim for damages against anybody. So if they take the boat lift out, it's gone. That's what the irreparable harm is. I mean, we have no claim for damages against the Babcocks. It would be under authority of the court. They're not doing it without the court saying you can do it. So I don't think we could get our money back, and I think that would be the irreparable harm.
What do you mean you couldn't make a claim for it?
Well, if you hold that they can remove the boat lift, they have authority to remove the boat lift. And then later it was held that it's within our riparian boundaries and we can put a boat lift back. I don't know how we're going to get our money back. I just don't see how that would work. And plus, that would be complete waste. And I know the law just doesn't things that are just wasteful and it doesn't make any sense. We should first determine the riparian boundaries. We're in trial. We have a case management plan. There's a delay naturally for this appeal, but we're going to have a decision. You know, the judge is going to make a decision as to the riparian boundaries. And then once we have that, is the boat lift within our riparian boundaries? We keep it. If it's not, we're going to have to modify things. Let's see. The other thing is the argument that they've making that we agreed to remove the boat lift. There is evidence that we've said that we agreed to remove the boat lift. There's immediate qualifications to those statements that if we have an agreement for the new boat lift, and as we argued in the motion for summary judgment, I think it's page 8 of our response, and they're going to bring it up to you. We also said at the motion for summary judgment, we might have to remove everything. But first we need a determination of the riparian boundaries. So there's never been an unqualified, we agree to remove the boat lift. And a lot like Judge Wozniak said, a lot of it is neighbors trying to accommodate each other. And we know, I think it was June 16 or 14, Mr. Babcock sent an email to Oric Construction saying, listen, we want to make sure you understand we're not removing the boat lift till this controversy is over. So I think that, you know, that was clear that we, you know, you can't really, there's nothing that would actually bind anybody. I really, in all due respect, I got to say, I don't think that email binds Babcock, and I don't think our conversation or, you know, giving up a little bit. Yeah, we'll remove the boat lift once we have a deal, once we have an agreement, or once the riparian boundaries are determined.
Counsel, you're in your rebuttal time, but you can keep
All
going
right,
if you choose.
that's enough. Thank you, Judge. I'll keep 4 minutes.
Good morning. Could I take just a minute to get set up here? Thank you. May it please the court. Good morning. My name is Ed Cheffy. I represent the plaintiffs, appellees, Mr. Babcock and Ms. Hamilton. I'm here with my colleague, Jonathan Fitzmaurice. I want to begin with the jurisdictional. We do not think this court has jurisdiction for this matter, and we disagree that anything needs to be destroyed. The order is to remove. The dock doesn't need to be removed. I'm sorry, does not need to be destroyed. You can remove everything, store those
Who's
pieces.
going to pay for the storage?
Good question, hasn't been decided. That has not been addressed. We offered when there was an alleged issue of fact, who's going to pay for the removal. My client immediately said, we'll pay for that, and that can be decided down
Well,
the
you'll
road.
pay for it, but we're going to seek reimbursement.
Right.
later on. Okay, so.
Correct, but we would front the money.
So
Yeah.
your argument is because you're disassembling the dock, you're not destroying it?
My point on the jurisdictional
Right.
question that your honors were asking about, there was discussion about the property being destroyed. Yeah, I don't see it that way. I see these boards, pilings being removed. I don't see anyone burning them or destroying them.
Which jurisdictional argument does this go to? The 9.130 argument or the certiorari argument?
The possession argument,
Okay, for
yeah,
9.130.
yeah,
Okay.
yeah. So, and I don't think there is irreparable harm, nothing that couldn't be corrected on the.
I mean, there's nothing in the record, counsel, that would suggest that these can be disassembled and stored and then reassembled together. Correct? Is there anything in the record that would lead this court to find that this is not destruction? I mean, as a matter of logic, how do we know the pieces fit back together? That the disassembly doesn't injure them in some way, that this is not actual destruction? I mean, I
Yeah.
think you still have to go from destruction to possession,
Mhm.
but I'm not following your argument
Okay.
that removing the dock is not destroying the dock.
Okay, and I'm just simply saying, a dock's a pretty simple thing to build. You've got your stringers, and you've got the planks on top, the deck, you got the pilings. I think those there would be some damage. There would be. There are going to be some bolts and nails, screws that are going to be removed. But I think, I don't know, it seems to me you could use those pieces in the future. But that's only dealing with the jurisdictional argument. And I will really rest upon the motion that we filed and the authorities on the jurisdiction.
For certiorari, do you agree that the trial court departed from the essential requirements of the law?
Absolutely not.
Okay.
Absolutely not. I think, and I'll get into that more in a moment, but I think the court reached the trial judge reached the only conclusion it could have reached based upon the evidence in the law in our judgment.
What
I
law
wanna-
did the court apply?
Well, the law, there is law, Hayes v. Bowen. An upland owner must in all cases be permitted a direct unobstructed view as well as direct unobstructed means of ingress and egress.
I don't see that in the order. I don't see any case law in the order.
Right, how do we look at the face of the order under the new summary judgment standard and determine that the court articulated and applied the law, what the law is that the court applied?
Well, we certainly argued this in our motion for summary judgment. Hayes v. Bowman was our key case. And then our key evidence was on that point, Mr. Babcock's declaration at Appendix 5. The as-built dock was constructed almost entirely in front of our property, substantially materially blocks our view, and restricts our ability to get a boat of any size in there, as you can see on the demonstrative. And this is reprinted at page 6 of our brief, this photo. And
Counsel, if I may,
Sure.
I'm just going back to the jurisdictional
Sure.
question. I'm still on that, and help me through this. But in your brief on page 13, you talk about the fact that in the motion for clarification and your response to the motion for clarification of this summary judgment order, you state, among other things, the boat lift was neither the subject of the Babcock's motion for partial summary judgment nor the court's order. So if that boat lift is not subject to the court's order, and he says that's all he cares about is a boat lift, why are we here? Are you going separate from what your brief says or separate from what you represent to the lower court? Or do you agree that that boat lift and obviously the pilings that would go along with it are not subject to the court's order and not affected by the court's order?
so the pilings on this side of the boat lift are affected by the court's order. There are the
So
court's.
would this then not be an accurate statement that you made to the court in your response to the motion for clarification that the boat lift was not subject to the court's order? How would that be an accurate statement? If what you're telling me is
So-
that two of the pilings that are connected to the boat lift would have to be removed, how is your statement to the lower court accurate?
The boat lift itself was not addressed in our argument or in the court's order. Now, I have always assumed if the court's order is carried out, that they would probably remove and store that boat lift until there's a decision about what is rebuilt. Whether there is a way to keep it there without these pilings on this side, I don't know. I
Is
doubt.
it usable? Can you get on the boat without that dock there? Can you launch the boat?
I think you could probably jump here. I'm not sure of that. But actually, I don't think without these pilings, I don't think the lift could hold the boat practically. So.
So the lift can't just stay by itself without the dock?
I don't think it can stay functioning without the dock.
Okay.
And counsel, you changed the wording a little bit. You said that the order did not address the boat lift, but your responsive motion to their motion for clarification said that the boat lift was not the subject of the order. So when I see subject, I mean, I think subject, it doesn't touch it. You know, if you say this doesn't touch that subject, then we don't talk about that subject. But if there's 4 pilings that connect to that boat lift and 2 of the pilings have to be removed, then absolutely. How can you make that statement that the lower court's order didn't affect, that it wasn't the subject, the boat lift wasn't the subject of the order?
Well, simply, and I appreciate your point, Judge Smith. Our point was simply, again, the order did not mention, there was not direct discussion of the boat lift. I do believe certainly it's going to be affected if the order is carried out because 2 of the pilings are connected to the boat lift.
Are those 2 pilings on what is look? I call it the left side. I guess that's the north side. If that's a north-south drawing orientation that we're looking at on that photo in front of us, are those 2 pilings that are currently connected to the dock? Are those within what you would call your client's rights?
I believe so. At least one of them is.
Okay.
So Mr. Smith testified, he put in this shrub, this page 24 of his deposition, roughly follows the property line. So if you extend that out, the piling, we believe, is on our side.
But you don't know because the trial court hasn't decided that yet.
Trial court has not decided anything about riparian rights. I think there is evidence in the record from Mr. Smith himself, page 24, the property line. He said he put this shrub, he planted it roughly on the property line, going like that.
I guess an issue I have following up on that, it seems to me that the remedy was awarded in this case before the merits were decided, before the issues of law, the riparian rights. Why is that not the case?
I respectfully disagree with that. There's one issue that was decided. Our summary judgment was very narrow by design, extremely narrow. Should this be removed? And the evidence to support that, and Judge Wozniak, I appreciated your question earlier. Is there any circumstance where this boat dock stays? There's not. There's no circumstance where the boat dock stays. This, and I've got this on the chart, everything in the record, citations, the Smiths have admitted this boat dock was never approved by anybody. They didn't approve it. We didn't approve it. Those are direct quotes. I've got 4 quotes. He says, I have no idea who approved this. Mr. Smith admits it is not acceptable. Mr. Smith repeatedly says it is terrible for you, and anybody can see it's terrible. It's non-functional for my clients. And Mr. Smith admits it was a mistake. And he does that several places in the pleadings. If you look at paragraph 26 of our complaint, Appendix 1, and their answer, Appendix 2, they admitted at a meeting, plaintiffs and Smith informed Orrick Construction they had agreed to tear out the as-built dock. Smith claimed there had been a mistake and placed the blame on Orrick. That is admitted in the pleadings. Now, somebody may say, well, I wonder if the attorney wasn't Mr. Yeslow involved in the trial court proceeding. Other attorney, well, I wonder if they just overreached, made a mistake saying that. No. I asked Mr. Smith in his deposition. I read this to him. Is that accurate? He admits it again in his deposition. And then he explained the mistake Orrick made. Keep in mind what happened back in December. Both sides agreed to what they called the kayak dock, coming straight out here. And then Mr. Smith met after that with Orrick many, many times. Had 10 or 12 different drawings we have found out after the fact. What Mr. Smith explained, pages 45 and 46 of this deposition, he was looking at a prior drawing with this coming out straighter, and he was saying, he was telling Orrick, according to his sworn testimony, move this end further towards my property. And he said that Warwick did the exact opposite and moved it way over here. And you've got this really just completely non-functional situation. Mr. Smith said when he came home, they were both out of town when this was being built. Mr. Smith said, I was stunned. And he said how terrible it was. And then at page 161, 162 of his depo, he said, I had nothing to do with where that dock was placed, nothing. And there was nothing I could do about it other than call him and say, hey, this ain't right. And that's Mr. Smith's statement. This ain't right.
Counsel, if the trust succeeds below on the merits at the conclusion of this case, when we actually have a final order that we're considering, if that happens, how is he made whole at the conclusion of this case, with the dock gone, with the boat lift gone?
I think there could be an order to replace.
Would your client pay for the cost of removal and for the cost of rebuilding the dock as it currently stands today?
If we are proven, despite a mountain of evidence, this was a big mistake and it needs to be removed. If somehow the trier of fact says, no, we don't believe Smith, we don't believe Babcock, we think this is the way it ought to be, yeah, I think my client would be required to rebuild it at his expense. I can't imagine that would happen, but I think that would be the logical, I think that would be the logical result. One of the, and again, I put myself in the shoes of the trial judge. The trial judge heard much of this evidence. It was all in the record. And then in response to our motion for summary judgment, and keep in mind, the relief we were seeking was just removal, nothing else. The last sentence of the response to the motion for summary judgment, and that's Appendix 15, pages 11 and 12. This is Mr. Smith's statement in response to the summary judgment. Defendants do not necessarily have objection to remove the as-built dock. That's right in their memo in response to the motion for summary judgment. Goes on to say, however, it must first be determined who is paying for the removal. We took that issue off the table. And they say there must be a determination of riparian rights. And that, in our mind, is a complete red herring. There needs to be no determination of riparian rights to have an order to remove a dock that everybody agrees was a horrible mistake and non-functional and terrible for my client.
Counsel, that brings me to my question, which is twofold. In the summary judgment order, what findings exist in the summary judgment order that actually support the trial court's ruling in this case to remove the entire dock and what you would say would also include the boat lift?
Okay, thank you. So the order, if we go to, and the other side's argument, oh, there are all kinds of disputed material facts. And we say there are no material facts in dispute at all, not any, zero. And here's what the court said. Paragraph 9 of the order. Contrary to the arguments of the defendants, there are no genuine issues of material fact in this case about whether the original joint boat dock was intended to be demolished or that the new joint boat dock was constructed in a way or in a location that either party thought was correct or proper.
But what difference does that make? If this goes back to subjective versus objective. If I walk in and I subjectively feel that I've bought a Lamborghini, but I walk out with a Toyota Corolla, don't we look at the documents? Don't we look at what the parties actually did? Who cares whether I felt like I bought a Lamborghini? This court's order uses words like each party thought this and each party felt this, but what do the facts actually show about what was agreed to? And don't we have to follow what
Sure. And the court,
show me in the record where there was an actual concession by the Smiths that this dock couldn't somehow be in conformance with their contract with Oric.
okay, let me go through. Appendix 14, this is a letter Mr. Smith wrote to my client. His words, I will swear under oath with the penalty of perjury I neither designed nor approved of the dock as built. That's Mr. Smith's statement. Appendix 13, I have no idea, this is Mr. Smith, I have no idea who approved the current location. It was not me. In his deposition, page 161, I never saw the plans for that dock. Nobody did.
But, counsel, that is his feelings. That's what's in his head. But what's on paper? Don't we have a paper signed document by both parties saying that dock is exactly where it's supposed to be?
No. What we absolutely do not. The deposition testimony from my client, he saw one drawing of where this dock was to be, and that was in December. He signed a later document that he read as saying this incorporates the prior executed proposal. There was no other design, no other drawing, no document attached to what he signed. And he has testified.
Yeah, but counsel, I mean, it's in the record that this was Oric's defense, was it not? Here's the drawing that I sent you all. Here's your document that you signed that approved this drawing. I mean, that's why Oric's not involved in this lawsuit, I assume, because they have the documents to show that you all approved it. My understanding was in reading the record that everybody's saying, whoops, I didn't look at that last set of drawings very well, and therefore this is the dock that we got when we were on vacation.
Okay.
Tell me that I'm wrong.
Respectfully, that's not what the record shows at all. The record shows my client says he never saw that drawing until after this dispute was underway. And Mr. Smith says, I'll give you the exact citation. His deposition, page 161, I never saw the plans before that dock was built. The parties agree on that.
But who's your contract with? Isn't your contract, isn't everybody saying that they had a direct contract with Oric? If you feel that there was a problem with that contract and non-performance, why would you sue the Smiths? Why not sue Oric and get them to build the dock properly? The Smiths aren't the ones that built the dock. It was Oric. So this gets to my problem where we're talking about the Smiths' feelings of a contract and the Babcock's feelings of a contract, but it's not the contract between the Smiths and the Babcocks. It'd be the contract between the parties and Oric.
Okay, these aren't feelings. These are facts. These are facts testified to under oath by both parties. They never saw that. They did not get that drawing. Now, should Oric have been sued? Maybe. May that happen someday, but that's not the dispute before this court today.
What right does your client have to sue the Smiths for Oric's non-performance of their contract, or as you would say, a faulty performance of their contract?
Because we found out after the fact that Mr. Smith was sitting with Oric day after day, 8 to 12 drawings we didn't know about. And we ended up with this mess. That's what we ended up with. Now, Mr. Smith says, oh, I told him to move it that way, but they moved it this way.
Counsel, your time's expired if you want to close quickly.
Okay. I will just say, I believe that Judge Foster, based upon the record before him, the arguments before him, especially the admissions, the statement in their own response to the summary judgment, did the only thing that a trial judge applying the evidence in the law could have done. Thank you.
Let me know when you're ready, Counsel. We have about 4 minutes
I just
left.
want to point out a couple of things real quickly. Judge Smith, paragraph 3 of Judge Foster's order makes it 100% crystal clear that both parties agreed to the contract to remove and replace what was built. So that's the ruling from the lower court at this point. With all due respect to my colleague, I know him well, he would not misrepresent anything to the court intentionally. Page 53 of Mr. Smith's deposition, which is Appendix 5 with the appellants, but it's grouped together, so it's hard to find. I suggest you use the appellee's deposition. Mr. Smith says, I signed the contract, I was wrong, and I admit I was wrong. I signed something I should not have. And did the contract you signed have a different drawing? No, I thought it was the same drawing, but evidently I didn't get out my ruler and measure, okay? So he admits he signed it. Mr. Babcock, paragraph 4 of his declaration, admits he signed it. They signed it. There's a deal. It was built in accordance with the contract. Once it was built, then everybody's on vacation, comes back and goes, this isn't what we wanted. Mr. Smith said, it's fine with me. Mr. Babcock's the one with the problem with it. Again, if we can keep the lift, we have no objection to removing the dock. We could probably put something up on the other side. But the order, what we have a problem with is the order irreparably harms us because it removes our lift. And I can tell you, there's no record evidence, but having a dock myself, you can't pull up a dock and put it back and move it. All right. You just can't do it. And before you can find that, you would need some record evidence that you can do that. And Mr. Chaffee telling you that I think my client might agree to something is not the same thing as binding his client to pay the cost of removal, the cost of storage, the cost of replacement, etc. If the court, when it finally determines the riparian rights, determines that the riparian rights fall within the boundaries of that lift. Thank you.
No, Counsel, I have a question.
Oh, sure, sorry.
No problem at all. I am bothered by the response to the motion for summary judgment, that last paragraph that counsel read. I know you didn't prepare it, but I want to give you a chance to speak to it. That combined with your counter declaratory judgment action, which I know, again, you did not prepare, but I'd like you to speak to it, which when you're asking for relief from the court, what you're asking for is an allocation of each party's responsibility for cost of removal and replacement. Why should I not view that in the lens of the irreparable harm analysis and say this can all be remedied by money at the end? Do you see what I'm saying, counsel?
I'm trying to fathom the two because let me go back with the position we took in the motion for summary judgment. What that last paragraph before the end, as I see it, what the attorney, Ms. Fink, was saying was, we don't think at the end of the day, if the dock has to be removed, we're not going to object to it. But before that's done, we have to determine our riparian boundaries, because if the dock falls within our riparian boundaries, it doesn't have to be removed. Okay, that's how I interpret it.
Do you want it?
I think it could be incorporated into a future dock, but I think the best thing to do would be to keep the lift and move the dock to the other side of the property so that we won't have to deal with the Babcocks. And I just don't know how it's all going to shake out. Once the riparian boundaries are determined and we know whose land is whose water rights are whose, people's attitudes might change and there might be a reapproachment. I don't know. But as things stand right now, I don't think the Babcocks want to share a dock with us, and I don't think we want to share one with them. We might have to have an easement and share an easement access to it, but somehow, figure out a way that we don't have to actually go on each other's dock. It's just got to be worked out.
So your time's expired.
Too early.
Do you guys have any further questions? Counsel, thank you for coming today. I know it was quite a drive for both of you. It was well argued and well briefed, and we appreciate your time.
Thank you, Your Honor.
We will be in recess.
You are.